Having looked at the major attributes of our common law system, the next thing I wanted to do is to just give you a little bit of historical background so that you understand how the system actually works and how it develops. To do that, I think it's best to use a little bit of history. So let's work out where this common law system comes from. So to understand the genesis of the system, we have to go back in time to around 1,000 years ago. And what we find is that at that time, what we had was local courts or moots, essentially warlords overseeing villages where there were these disparate legal systems that were in charge of governing their own territorial area. So if you can imagine that you have a country, let's draw a country, and essentially what we're saying is that there are these legal systems in the country that are all quite separate. Now for the history buffs, this date might sound familiar, right? William, Duke of Normandy, or also known as William the Conqueror, comes over from France and conquers England. As such, he takes the English throne and institutes an approach to the law. What he says is he's not going to change the law, but instead appoints a series of judges who go around the country applying the laws in place. Now, this really gets turbocharged under Henry II, who sends these royal justices on circuit. And actually, we still do that. We still have courts going on circuit. So, for instance, the judges that sit in the Supreme Court in Queensland will go to the regional centres when they're going on circuit. And these judges start recording their decisions. They start recording what happened, what they decided, and really importantly for us later, the reasons for these decisions. So what we see here is William said, I'm not going to make laws. So I'm not going to issue that. That's not strictly correct, but what he's saying is I'm not going to become the one who sets it out. And instead, the way they create this legal system to control everything is to having judges, right? And these judges make the laws in different regions similar. They start deciding similar cases in similar ways. They make the law similar. They make the law common to all of these different areas. If you have the same judges deciding things in the same way in each area, then what you end up with is a common law between the different areas. Now, what we next see is that over time, gradually, the king loses power, the monarch loses real power, and at the same time, the law set out by these judges becomes increasingly inflexible. That's because they had to follow the rules. We'll get to the doctrine of precedent, but in essence, because of the doctrine of precedent, the area of common law, the judge-made law as it first was, became too inflexible. And so what do if you don't like the ruling of the court? Well, you appeal to the king. And that's what people started to do. And as they do that, the king says, well, I actually want to be out having a good time, conquering things, hunting, etc. I don't want to be listening to people gripe about their legal cases. So he establishes another court, the Court of Chancery, which has this area of law we refer to as equity. So what we can start to see is the rise of these different courts, so common law and equity. And depending upon what your problem was, you would go to these different judges. The judges themselves were bound by the doctrine of precedent to decide things the same way as other judges did, according to some rules that we'll get to. But we're getting this developing common law that now starts to adapt and specialise based upon these courts. So at the same time the courts are developing, we can see a transfer of power from the monarch to Parliament. And over time, we see the rise in legislation. Now, really, when you think about it, the idea of legislation and making the law through the authority of the state is essentially the same as when the king was making it, only now it's done via democracy. So this is one source of our law, legislation, the use of that authority by the state, the maker of the laws. But in the case of the common law system, because of what happened over here where William the Conqueror said, I don't want to be doing a lot of making this law, and implemented a different system of judges deciding things the same way, we end up with two sources of law. Case law or judge-made law, and also legislation. Today, realistically, these areas of law have largely condensed, although judges still specialise, and there are certain specialised courts we'll get to, but they've largely condensed into one area of law that the judges practice. But we still have this legislature where Parliament exercises the power of the Crown, and we have the combined legal systems in place. So if we flip back to a slide before, this explains how we ended up with two sources of law, legislation and case law, and also how we ended up with this idea, or these historical courts in these different areas of law. It's the way that our legal system actually evolved. Now, this next little section I know can be a little bit confusing for students. It's about understanding some of the terminology and how we classify law. Why is it confusing? Because these systems aren't mutually exclusive and often use terms, the same term in different ways. Just like we said, common law can mean the system, like we have in Australia or the UK or the US. It can also mean judge-made law. So common law is the judge-made law within a common law system. And it can also mean the specific area of common law that became rigid and hidebound, right? That area of law that judges made within all of judge-made law. So we have these different systems that can sometimes use legal words differently. So when we're looking at a classification system, we have to understand what it's trying to do and how it's using the specific words, because it might be different to how another classification system uses the word. So I know it can be confusing, but you've got to understand how the word works in context. I think the second thing to think about how this operates is that we do this all the time as humans. We classify things in different ways. So for instance, think about animals. I could classify animals as to how many legs they have, right? Or how many limbs that they have. I could classify animals according to whether they're mammals or not. And I would get different answers as to what an animal is. So a goanna might go in as a lizard, not a mammal, but it would have 4 legs just like a cow, which is a mammal, right? So the systems are doing different things when we classify them different ways. That's the important thing to understand. Now, second thing, why would I even bother with this? You're not going to become lawyers, so why should you care about this particular issue? The main reason is so that you understand this issue of jurisdiction and how a single event can have multiple legal consequences. The classification system helps explain that and helps you understand why a legal answer will be what it is. For instance, imagine that I'm going to punch you, right? Okay. So that is a criminal act, so it has a criminal law connotation. But there's also a civil law action. I think it's battery, is it? Battery assault. There's a tort against the person, which is a different issue. So under criminal law, you can't get compensation for me traditionally, right? Under the tort, you can. They're two different laws. So there's one act, me punching you, two legal issues at least occurring. There's a third legal issue, my contract with QUT. They might want to sack me. So you can see that when one thing happens, it affects multiple areas of the law. And we need to know how that actually plays out. Another reason it's super important is that the way the law operates can be different under some of these different categorizations. In particular, the difference between criminal law and civil law when we get to it. So you need to understand that the rules change depending upon how you classify the particular law that you're dealing with. That's why we do it. We don't expect you to know it extensively, and I'll try and highlight what we want you to be able to remember. Remember, everything's open book, so you don't have to memorize it, but you just have to understand what's going on. Okay, with that all explained, let's get into some of these systems. The first major classification that we have is public law versus private law. Public law is when it's about the relationship between the citizen and the state, between the person or people and the government. So things like tax law, criminal law, administrative law, constitutional law, they're public laws because they govern the relationship between the government and citizen. The government taxes you. The government enforces crime law on you. The government administers legislation. So, for instance, the government gives you a driver's license. You're licensed by the government. So it's about issues between the citizen and the state. Private law is about relationship between citizens. So that would be an example of I have a contract with you. It's about our relationship with each other. Property rights, commercial law, company law. They're the kinds of good examples from business around private law. For the purposes of this subject, we want you to concentrate on understanding what constitutional law is. That's super important because that determines a lot of jurisdiction in Australia. We want you to understand what administrative law is because the government often makes businesses do a lot of activities and undertake a lot of compliance. Tort law, which is an area of private law, about how careful you need to be. Contract law, doing deals with each other. Company law, the law regulating corporations. Now, it might not be immediately obvious, but each of these areas of law are important to our business environment. So we want you to understand what they deal with and how we might classify them under our various systems. Now, here's where it starts to get confusing. You might remember that we said earlier on that there were civil law systems, like in continental Europe. Well, for this slide, I want you to forget that because we're not using civil law to mean that. What we're actually using it to mean is a way of classifying law about relationship between members of the community. And in civil law, what we have is an action, so litigation or enforcement is undertaken by the person, not by the state. As a result, what we have is a different standard of proof. What is more likely to be the case, given what's going on, right? It's not strictly correct, but that's a way of thinking about it. So in business, examples of civil law would be contract and tort law, negligence, which we'll come to. Now, contrast that with criminal law, right? That's probably the area, if you've done no law, that you're most familiar with, that you see a lot on TV, right? So it deals with criminal offences and penalties. This is super important. This is about punishing people. That's part of what criminal law is about. It's about other things, but one of the things it does is punish people. Civil law never punishes someone, right? It's about rectifying a harm. So the objective is different. Now, the only people in our society who are allowed to punish others legally is the state. Right, that's what we say. No one can do that. It's the state who punishes people. They prosecute people who commit a criminal offence. Okay. So if I assault you, if I punch you, then it's not you who takes me to court for the criminal issue. It's the state or the Crown. And the symbol that gets used in cases is, I think it's Regina, for the Crown. So we can see here that it's vastly different to the civil issue. I could punch you and you could want to get your hospital bills paid. If you want to get your hospital bills paid, then you need to sue me for a tort. So one act, me punching you, two different things actually going on. Now, in the tort, if I punch you, and just say I say, well, I didn't punch you, I slipped and accidentally hit you. Well, what the judge has to decide is, on the balance of probabilities, is it more likely that I slipped and hit you or more likely that I punched you? And depending upon the facts, you might say, on the balance of probabilities, it's more likely you punched him because it's hard to imagine how you would hit someone that hard. But criminally, because I might actually go to jail and the punishment is so high, we have a different standard. The standard in a criminal issue is beyond a reasonable doubt. Is there any other reasonable explanation? Are you really sure that he punched you, that this person punched the other one, right? There's got to be no other reasonable explanation. And depending upon the facts, it might be unlikely but possible that I slipped. So you might end up criminally saying not guilty because you can't establish this standard. You can't say that I definitely didn't slip. So here you have a situation where civilly you might get the hospital bills paid for, but I might be found not guilty legally. Notice, that does not equal innocent. So there's a very important issue about criminal law as well. So if we look at these two areas of law, civil law and criminal law, we see that we have different terminology, different standards of proof. The use of juries varies across them, what the result is and what the outcome is. So if you're thinking all law is in here, no, the vast majority of business law is in here. And things like the standard of proof being the balance of probabilities is a very important distinction when compared to the standard of proof required under criminal issues. As I was saying earlier, just as there are different ways of classifying animals, there are different ways we can classify law. For us, we need to think about public versus private law, criminal law versus civil law, case law versus statute law, and then within case law, common law as opposed to equity. If we understand those concepts, we understand the development of our legal system, and we also understand some of the major differences about how courts approach different legal questions. And to round out this discussion, I've tried to produce some of the most confusing areas of terminology you might find in the course. Common law is one that can be used multiple ways. Civil law is a word that can be used multiple ways. And importantly, the words legislation, act, and statute can mean the same thing. Okay, these topics become far more important when we start looking at a scenario where an act or incident occurs in a scenario, and you have to know which area of law that you want to apply. Now that we've looked at our legal system as a whole, let's start looking at a little bit more detail of Australia's legal system.